Good morning. I am Father X, talking about how fathers can win their child custody case. Today, we're diving into the best interests of the child. Let's get to it. Why does this matter? When parents are divorced or separated, both parents have equal rights to be a child's primary custodial parent, and the choice between the two parents is supposed to be made based on the best interests of the child. So you have to know these in order to effectively fight for custody of your children. And you might be thinking that judges don't follow these rules because they're gender biased in favor of mothers. We'll talk about that in the next episode, 5B, where I highlight how judges ignore the best interests of the child, but how you would use these factors to overcome the judge's efforts to just rubber stamp the mother. That said, if you want 50-50 or primary custody of your children, you have to prove that it's in their best interests to have you in that role. The mother is supposed to prove the same thing if she wants custody. As I discuss these best interest factors, I want you to think about the best interests in different age ranges. Children in these different age ranges have different needs. An infant from 0 to 6 months old simply needs to be fed, to sleep, to have their diapers changed, and to be given constant love and attention. A child 6 months to 4 years old needs to be constantly monitored so they don't stick their finger in an electric outlet, like my son always tried to do. Children 5 to 12 years old are in school, and that becomes one of the most important parts of their life. And teenagers are striving for independence, as well as needing to focus on their education in order to become contributing members of society. I've oversimplified the needs of children at each stage, but you understand what I mean, and you'll think deeply about these needs for your case. In everything that I've read and seen, I don't think the family law industry intelligently breaks down the needs of the child based on different age ranges. They just make shallow arguments. So if you present your custody case and intelligently discuss the specific needs of your children based on the categories and their age range, you'll likely be miles ahead of anybody else in that courtroom. This will be a key part of your strategy. Let's get into the best interest factors that courts are supposed to use to determine child custody. I pulled these together for my case based on reading tons of appellate court decisions and case law, as well as countless articles on the best interests of the child. Each source usually lists only a handful of the best interest factors, but I combined them all here for a complete list. For each factor, think about your specific strengths and weaknesses in meeting these needs. And think about the mother's strengths and weaknesses in detail. Come up with as many examples as you can for each. And to set your expectation, this isn't an exercise that'll take you 1 or 2 hours. It'll take you weeks and months to think thoroughly to prepare for trial. Week after week, you'll come up with new ideas about what makes you or the mother a good or bad parent. So start now. And be aware that this exercise right now is just for you to start preparing for your case. As you finish this, then you'll decide which portions you want to present in court. Let's get to it. Parents' weaknesses. Domestic violence. A child should not be primarily raised by a parent who is violent or has anger management problems. And if the parents have a high conflict with each other, or there is domestic violence, then 50-50 custody is a less likely outcome because of the parental coordination required. Victims are generally not forced to engage in parental coordination with their abuser. Findings of child neglect and abuse. It's better to keep the child away from the parent that has abused the child. Alcohol and drug use. If a parent uses drugs or drinks so much alcohol and so often that it prohibits them from effectively parenting a child, that's a factor. It doesn't mean you have to completely abstain from alcohol, just be responsible. Mental and emotional stability. If a parent doesn't have mental or emotional stability, it's less likely they can raise their child to be stable. Disability and physical, mental health of the parents. This matters if a parent is not physically capable of raising the child, or if a parent has mental health issues that prevents them from raising the child. Think about significant disabilities here and not just minor disabilities. The needs of the child. The basic needs of the child. This refers to providing physical needs such as food, clothing, shelter, and safety, as well as a child's medical needs. If a child has complicated medical needs, then the parent who's better able to meet those needs has the advantage. Ability to provide for the child's emotional and psychological and social development. This is an extremely important factor. It refers to providing emotional needs such as love, acceptance, and a sense of belonging. A child should be raised in an emotionally stable environment where the child, for example, is not having to worry about the mood swings or anger management problems of their parent. You don't want a parent that's going to impose psychological issues on the child, and you want a child raised to socialize effectively with other human beings. The child's intellectual development. It's important for a parent to effectively encourage and participate in the child's education. This is extremely important. Parental guidance provided by parents. This relates to how much mentoring and teaching life skills a parent provides for their children to help them grow. Preferences of the child. There's no hard and fast rule on when a child's input matters because it depends on their emotional maturity. But 13 years of age is around the time where this becomes more of a factor. Forensic evaluation. The forensic psychologist will evaluate the ability of the parents to raise the child. It happens often, but not always, that the judge follows recommendations by the forensic evaluator. That's why we'll have an entire section devoted to this. The parent's home. The home environment should be safe for children to live in. The common joke about children's services is that their abilities are limited to only making sure the child is not living in a crack den or a brothel. Availability of parents or adequate childcare. Children who are not yet in kindergarten need constant supervision, so an unemployed parent is often more available. If a parent travels frequently for business and can't take care of the kids after school or at nighttime, this will factor into a custody decision. If a parent works, they'll need adequate babysitting. Financial stability and ability to provide for the child. If one parent is more financially stable than the other parent and can provide for the child on a routine basis, this is another important factor. A court will generally try to avoid splitting up siblings. Often, all the children will stay with one primary custodial parent. This rule can be broken if one child is much older and in their teenage years. Also, if one parent has stepchildren, that may or may not be counted as siblings depending on the situation and the closeness of the siblings. Prior custody arrangements and co-parenting. Maintaining stability of prior orders. If a child is already living with one parent for a long period of time, the courts tend to keep it that way in order to prevent having the child's life completely turned around by switching primary residences. It depends on how big a change that is, but you can definitely make the arguments to justify a change based on the other best interest factors. Existing informal or written custodial agreements. If, before going to court, the parents already had a custody arrangement between themselves, the court is likely to go with that, at least temporarily. But you can always try to prove that the child has gotten older and circumstances have changed, or that there are other best interest factors to consider. Primary caretaker. Whoever has acted as the primary caregiver is often made the primary custodial parent. But, again, you can try to prove that circumstances have changed and that going forward, you are the better parent. Fostering the child's relationship with the other parent. Each parent should be willing to have the other parent actively involved in the child's life. A parent who proactively tries to remove a child from the other parent's life without a legitimate reason is acting in the worst interests of the child. If a parent has previously abducted the child away from the other parent, that's a bad scenario, and the kidnapper is at a disadvantage, unless there are legitimate concerns, such as truthful allegations of domestic violence. Parents' behavior in court. A parent's behavior in court is observed and noted by the judge, and that's why I made episodes 4A and 4B to discuss how to play nice in court. You have to be assertive to state your case, but if you are aggressive or angry, even if it's justified, the court is likely to claim you can't meet the emotional needs of the child. Lying and manipulating the court process. If a parent is found lying in court or making false allegations about the other parent, this is a factor that must be considered in determining custody. After all, what kind of morals can a parent teach a child if the parent doesn't have morals themselves? And a parent who makes false accusations to get primary custody is obviously trying to alienate the child from the other parent. Other factors. Religion is less of a factor nowadays, but depending on the community and the parents, a religious upbringing might be important. A law guardian has input into the best interest of the child. I discussed that in episode 3D, where the law guardian is just another lawyer in the process, representing your child. But I have only heard horrible things about law guardians, so if you can avoid having a law guardian for your children, I think that's generally the best move. I just listed out 24 factors. Not all of them will be relevant to your situation, so you would just eliminate the irrelevant ones from your discussion. For example, if your child does not have any brothers or sisters, then siblings are not a factor. If your child does not have any serious medical conditions, or there are no allegations of domestic violence, then those are not factors. If in your case there are 12 relevant factors, there's no standard that says one factor is more important than the other factor. Domestic violence is probably the one that's weighted the most. Even if you're a better parent in 7 factors, and the mother is better at 5, the judge can still give custody to the mother because the judge has all the power. It's even possible that you can be better at 9 out of 12 things, but the judge can say, these 3 are more important, so the mother gets custody because she's better at those. So be aware, none of this is scientific, and there's no objective numerical measuring scale to rate the parents on each factor. Theoretically, judges are supposed to ultimately make a decision based on the parent that's most able to take care of the child in the long term. When parents bicker in court over nonsense, it doesn't show the judge which parent is more able to take care of the child. And if that happens, you should assume that the court will just rubber stamp custody to the mother. But when one parent clearly demonstrates they're more attuned to the needs of a child, then the judge should be more likely to rule in favor of that parent. My strategy, in my case, was to completely neutralize my judge's gender bias and incompetence. So I set out to prove that I was a better parent across 100% of the relevant factors, which were about 12 of them for us. I didn't want the judge to have even one excuse to say the mother was better at even one factor. So I prepared my evidence and testimony to prove that I was better across the board. That's how I won. For your trial strategy, I recommend that your starting point is to try to prove that you're better at all of these factors. Otherwise, you leave your child's future to the whims of a judge. But don't worry if you can't achieve perfection. The goal is to work with what you have as best as you can. The more factors in your favor, the better your odds. There are 50 states with 50 sets of laws, but they have the same common ideas that both parents have equal rights to their children, and custody decisions are supposed to be made based in the best interest of the child. You have to focus on your state's laws. I found there are 2 ways that most states write their laws. Here's a quick summary to help you in your research. In example 1, this state says that both parents have equal rights to raise their children, and it says custody must be decided based on the best interest of the child, and the best interest factors are laid out in the law. And in this example, you don't have to read the screen, it's too small, but the law says custody will be decided based on the emotional needs of the child, psychological needs of the child, domestic violence, etc. If your state's list of best interest factors is shorter than my list, then use extra items from my list, because it'll show that you think about parenting more profoundly than even your state legislature. And my list has items that nobody can dispute as being important for a child. In example 2, this state's written laws say that both parents have equal rights to raise their children and custody should be decided based on the best interest factors. But they don't tell you what the best interest factors are. It's unclear. So for states like this, how do you know the best interest factors? Well, first, you can start with my list because it's fairly comprehensive. But for each state, it's based on case law of that state. And what does that mean? In episode 3A, I showed you the hierarchy of the court system. You can see it in this chart. At the lower level, there are trial courts, like the place that's holding your custody hearing. Above the trial courts, there are appellate courts that each trial court directly reports to. In other words, if you appeal your judge's decision, that appeal goes to the appellate court directly above your trial court. And the appellate courts report up to one master court of appeals for that state. Each state will have different names for these courts, but the hierarchy structure is similar across the states. Over the years, appellate courts for your state have received many appeals on child custody cases, and these cases are decided upon by the appellate courts. And the appellate courts, by their rulings, tell everybody that the best interest of the child is to be free from domestic violence, to have their emotional needs met, and their educational needs met, etc. This is an example of case law in New York State. The case of Felty versus Felty from the Appellate Division in 2013. The court says, in determining those best interests, the court must evaluate the totality of the circumstances. Among the factors to be considered when evaluating the child's best interests are the parental guidance provided by the custodial parent, each parent's ability to provide for the child's emotional and intellectual development, etc. I don't want to bore you now by reading the whole case, but you can Google it and search for Felty versus Felty in New York. It's only a few pages long, and when you read it, I think you'll realize that these cases are written in plain English. You don't have to be a lawyer who's an expert in legal language. These are simple stories of what happened to other families. Case law will be an important resource for you, and I'm not going to let you do this alone. I'll do a future episode where we get into how to research case law. But when the appellate courts set this kind of ruling, it means that the courts below them must follow those rules in the future. In the court world, there's a term called precedence. It would be chaotic if courts made different decisions on child custody all the time and changed the rules. Citizens need to understand what the rules are so they can be applied consistently to everybody. Therefore, the lower courts cannot vary from precedence that was already set because it would create inconsistency. A judge would need a fantastic reason to make a ruling that goes against prior rulings of their appellate court. So far, most of what we discussed in this episode is about the theoretical way in which family court judges are supposed to make custody decisions. The theory is great to know, and you truly need it to prepare for your trial. But we also need to know how judges actually make custody decisions so that you can neutralize their errors. So the next episode will be mistakes judges make in child custody and how dads can overcome them. These might be the darkest days of your life, and I'm making these educational videos to help you navigate this nightmare. If you subscribe, you can get updates when I post more videos. Thank you for liking, subscribing, and sharing with your friends who are in a similar situation. If you like, subscribe, and share, it'll also help the YouTube algorithm get this message out to more fathers in our position.